Hello, welcome. The room is filling up. Good evening. You have joined the National Aphasia Association's Ask the Expert. We're going to get started in just a few minutes. We like to make sure that everybody is able to jump in as a participant. As you know, we can't see you, but you can see us. And this webinar is being recorded. We'll be able to put this up on our YouTube channel afterwards. And yeah, we're going to be getting started in just a minute. Feel free to jump in the chat and tell us where you're calling in from tonight. I'm actually up in Allentown, Pennsylvania, even though you all know that I live in North Carolina. Chris was just telling me the pollen is lovely there this time of year, so
it's definitely a lot.
I'll be back there tomorrow. Okay, so it looks like people are in and getting ready. We're going to talk a little bit, but definitely jump in the chat. Tell us where you're calling from. Hey, Jill, nice to see you. To not see you. Join us. Okay. I am going to go ahead and share my screen. St. Paul, Minnesota is in the house here. Nice. Welcome. Okay, I'm going to share my screen here. Don't have it. And we're going to talk a little bit, really interesting topic tonight. I'm thrilled that we're going to be welcoming Chris in here today, but we'll tell you a little bit more about him and where and why he's calling in today. But you are here for Ask the Expert, which is the National Aphasia Association's monthly program. We bring in experts to help people with aphasia and their families along this journey. Along the way, if you have any questions and comments, please put questions in the Q&A, which is on that black bar on the bottom of your screen, and just put in what you want to ask. Also, feel free to say hello and make a comment. Give us some feedback in the chat section. We are going to answer as many questions as we can about tonight's topic. If we don't get to your question, or if you have any other question during this about aphasia, please email the National Aphasia Association at answers@aphasia.org, and we will get back to you. Also, you could join our new conversation group. This started just a couple months ago, and Catherine and I have so enjoyed the new conversation group called After the Expert. And I want to tell you that we started this group because of you all who, after one of the Ask the Experts, had more to talk about. You wanted to share your experiences, and we needed to learn your experiences so that we could serve you better. So we have a group the Wednesday after Ask the Expert. So it'll be next Wednesday from 12 to 1 Eastern time. And the group will be about this topic. Of course, we would love to hear your feedback, your thoughts, and then we can follow up with questions with this wonderful organization I'm going to tell you about now. So if you want to learn more, go to aphasia.org or just scan that barcode there. One other new thing that I did want to mention, and I'm not sure the word has gotten around yet, for speech pathologists are now able to get one professional development hour, one PDH as they call them, from the ASHA certification maintenance program. So if you watch it live, at the very end, we will share a certificate specific to this course, and you can print it off and you can get your PDH. Okay, so without further ado, I'm so excited to welcome Christopher Worthington. I'm going to read this for everybody, and then if you'd like to add anything, Chris, about your background, you can feel free. With a background in both law enforcement and legal practice, Chris Worthington brings a unique perspective to his role as legal production manager at Carolina Family Estate Planning. Known for his steady leadership and team-first mindset, Chris plays a key role in streamlining internal operations and supporting the firm's mission of delivering high-quality, client-focused service. And I will tell you, and I know you'll mention a little bit about Carolina family estate planning, but both my family and many people in our area here in North Carolina have utilized this amazing legal firm to help with all of these kind of questions. So we're really excited to have such an expert with us today. Originally from Massachusetts, I think we have a lot of people in the NAA area, in the Boston and Massachusetts area. So if you're from Massachusetts, chime in here. Chris has lived throughout Chris has lived throughout the Northeast before settling in North Carolina with his wife, 3 children, dog, and cat. Chris holds an associate degree and a bachelor's degree in criminal justice, and earned his Juris Doctor from the Massachusetts School of Law. He is a licensed attorney in Massachusetts and a retired police officer, honored for his acts of bravery and service, including the Medal of Valor and 2 life-saving awards. While his career has taken many forms, a deep commitment to service has been a common thread, whether in the field, the courtroom, or now behind the scenes, helping clients and colleagues alike. Outside of work, you'll find him on a nature hike with his family, in the kitchen preparing his famously delicious chicken cutlets. Okay, I'm getting hungry now. Or cheering on the New England Patriots. He never misses a game. He also enjoys playing Texas Hold'em and is always up for a good laugh. So welcome so much, Christopher. We're thrilled you're here.
Thank you so much. I appreciate it. I must add, though, I'm terrible at Texas Hold'em, even though that's in there.
Okay. Well, Chris, we're thrilled to have you. I know you'll tell us a little bit more about this law firm, but also in general, the planning for your future and things that come up. I know that we struggled when my mom had her stroke, and as by the way, a policeman saved my mom's life and got a life-saving award when she was driving during her stroke. I thank you for your service in that way as well.
I appreciate that. Thank you very much. And aphasia is one of those things that really touches so many different people, myself included. I think I was telling you a bit earlier, but my great aunt and my great uncle both had strokes and had varying degrees of aphasia, but we love them nonetheless. And of course, they were able to communicate that love back to us, and we certainly appreciated that. So it was a great opportunity. I was happy to jump on this to be able to talk to everybody about, estate planning, particularly as it relates to elder.
Great. Thank you so much. And as you said, people are still there and they need that representation. So I am gonna, hey, Kathy, nice to see you. I'm going to put my camera off and it's all you, sir. So let me know if you have any issues, and welcome everybody. Thank you, Chris.
Fantastic. All right, I'm going to get my screen share up. I hope you all can see this. Again, just to reintroduce myself, my name is Chris Worthington. I'm super excited to be here. I am a licensed attorney in Massachusetts. My role now as the legal production manager with the Carolina Family Estate Planning has taken me away from practicing law, but managing systems and processes. But my background really was in estate planning, and it was the first area of law that I really fell in love with after police work. So I'm glad I could join you all, and I'm glad you could join me. I think it's wildly important that we have conversations about estate planning and your future. I know that planning for the future can feel a bit overwhelming at times, especially when you're facing health challenges, particularly like aphasia. But today I wanted to show you how a few key steps can really give you and your loved ones a bit of peace of mind. What is estate planning? Estate planning isn't just about what happens to us after we pass away. It's really about making sure we stay in control of our own choices. If something happens and we're unable to communicate, a good plan really makes sure that our wishes are clear, that they're concise, and that they do exactly what it is that you want them to do. It also helps prevent unnecessary stress for yourself. You have enough that you're having to deal with, particularly when you're dealing with an illness. And it also limits the stress for your family members, I believe, as well. Um, Really, the best time to plan is before a crisis. But even if there is a crisis, there is avenues for you, so don't fret. Um, the good news is that planning doesn't have to be complicated. I know a lot of folks from time to time really think it's overwhelming, and I want to kind of minimize that, and I hope you walk away feeling that way tonight. Oftentimes we hear estate planning and immediately we associate it with just a will. And I always think of a movie where you have everyone in a room and the attorney is reading the will. I'm here to tell you that doesn't really happen. But estate planning is really more than just a will. It's about making sure that if something were to happen, that you, one, have the right people in place, and two, they can step up and they can step in and they can really help you to really drive the bus with your decisions. A good and an effective estate plan really includes a few important tools, and we're going to discuss these as we go through. Typically, what you'll find is they'll have powers of attorney, some form of healthcare directive, and it varies from state to state, wills, and sometimes you'll find trusts. So let's take a closer look at what each of these documents really do. First up is our power of attorney, and I really want you to conceptualize this as your financial power. You're giving that power of attorney to someone else that you trust, that who can step in for you and help with your finances if it's ever needed. This particular person can be called your agent. Some jurisdictions call them an attorney in fact. But essentially what they can do is pay your bills. They can handle your banking. They can take care of your financial matters. The best part about this is you decide what scope of power that they have and when they can use it. Obviously, this is really, really important because if you don't have a power of attorney and something happens to you, your family might have to go through a legal process, which can be expensive, going to court, seeking either guardianship or conservatorship, depending on the jurisdiction that you live in, and making a situation, especially when you're in crisis, that much worse. And so the power of attorney is a great tool in the toolbox of estate planning. Next, in conjunction with the power of attorney, we have our healthcare directives. These directives really are serving kind of two purposes, but it lets someone you trust, one, make medical decisions on your behalf for you in the event that you can't speak or advocate for yourself. This typically includes a healthcare power attorney. It can also be named a healthcare proxy. It is, again, jurisdiction specific. In addition to that, you may see that there's a living will or an advance directive, again, jurisdiction specific. But this particular healthcare power of attorney, as we'll call it here, and the living will, basically, well, I'll back up. The healthcare power of attorney empowers someone to make decisions on your behalf. The living will really communicates that intent to your doctors and what kind of care you really want. That's super important from my perspective because it prevents confusion. Again, remember the context. Something as bad has happened. You're in the hospital and people really want to help. And what we want to limit is that confusion. So this really makes sure that your wishes are honored. And that's wildly important. Again, some states use different terminologies, but just generally speaking, you may hear healthcare power of attorney, healthcare proxy, advanced medical directive, living will, and the like, but they're all kind of directives that are putting someone in place to help you make decisions, and as well as making sure that medical staff know what your decisions are. The will, as everyone before I said, when you think of an estate plan, most people think of a will. A will is really a document that says or identifies who will receive what of your assets when you die. Additionally, if you have minor children, that will can appoint guardianship for those minor children. But there's something a lot of people don't realize with the will. Your will has to go through probate court. And I can't tell you how many times I've had conversations with people from many different backgrounds and many different jurisdictions who are really frustrated with the probate process in and of itself. So before anything can be distributed under the terms of your will or devised under your will, you first must go to the probate court, and certain formalities have to be met before those distributions can be made. That's why some families, because of this probate process and because I'm sure of some of the stories that either some of you have experienced or even heard yourselves, they choose to use trusts as an option. And we're going to talk about those next. So what is a trust? It's a powerful legal tool that allows assets to be transferred without having to go through that probate court process. We find that it's especially useful for protecting assets, providing care for loved ones, and for making sure that money is handled in a responsible way of your choosing. As an example, if someone has a disability or a special need, a trust can ensure they receive support without losing important benefits. Many people think trusts are just for wealthy, like I think the Vanderbilts or the Rockefellers, but in actuality, they're used for families of all sizes. A great analogy that I heard, and it was by our owner, Jackie Bedard, is the radio flyer red wagon. If you can envision the trust as the red wagon itself, the assets and the things that you've acquired, and if you're young, it's a teddy bear. If you're an adult, it could be any other asset. You put it into the red wagon, and you, as the owner of the wagon, get to pull that handle and direct where that trust goes. That's a really good way of thinking about it. It's oversimplifying it, of course, but it's just a good general way of thinking about it. So let's recap. These are the four main essential tools for estate planning. Again, your powers of attorney will help with finances. So your attorney, in fact, will stand in your stead and make financial decisions on your behalf. Your healthcare directives, they make sure that your medical wishes are followed. Your wills, they will determine who gets what after you pass. And trust overall just generally helps to avoid probate while offering certain asset protection. Putting these pieces all together really is a solid and effective estate plan. And that's when we're saying estate planning, I really hope that you will now visualize this when you're thinking about that as you proceed forward. Up next, we're going to talk about some common concerns people have when starting this process. Because it can be overwhelming, I understand that and I respect that. There are so many people that I've talked to that have put off estate planning because they thought they had plenty of time. And when we meet them in crisis, that's when they grow more frustrated. And I understand and respect that. So that being said, there is no better time than now or before a crisis to start kind of considering your estate plan and what your wishes are and what you want to have happen with your assets. If you wait until a crisis happens, your options sometimes can become limited as to what you can do. And that can be for a number of reasons, whether that be for certain benefits that you may receive or qualify for. Your asset picture may be too high or maybe too low. Regardless, that process can become even more stressful than the crisis itself and only compound. So by planning ahead, you're really just giving yourself and your loved ones that gift of peace of mind and that reduction of stress. So many folks do assume that any attorney who helps with estate planning, that they're kind of the same, and there is a distinction. The biggest difference between an attorney, say, that practices general estate planning versus an attorney that focuses in elder law is that the elder law has additional training in certain areas like long-term care planning or Medicaid eligibility, and working with clients who have conditions like aphasia or dementia or mobility challenges. They tend to understand that legal and financial considerations, and they come up with sort of conditions and terms for the planning, and they can recommend strategies to really help protect you and your family over a long term. Now, I joke, there's plenty of jokes about attorneys out there, so I'm not disparaging general estate planning attorneys, but when we're talking about someone who is in crisis, it's really important that you find the right attorney for you, particularly as it relates to, long-term care planning or someone with dementia or aphasia. And that's where the elder law attorneys really have a little bit more training over and above. So thus far, we've really covered the key legal tools used in estate planning, but planning for the future really isn't just about what happens after you pass away. It's really also about ensuring that you have a strategy for potential long-term care needs. As you all know, the cost of care is rising, and without proper planning, many families will find themselves in the unfortunate circumstance of a financial crisis. So I want to kind of dig deep on about how to plan ahead and to protect both your health and your assets for the long term. This stat shocked me. I guess I was a little naive from time to time about the actual cost of or how expensive long-term care can really be. This was pulled about from here in North Carolina, that the average cost of a nursing home is approximately $100,000 a year. Those costs, unfortunately, are rising, and assisted living and in-home care can also be very expensive. Most of these services are private pay, which means that the families are going to have to cover those costs out of pocket, which can cause undue stress financially for your loved ones. And we really want to avoid that. A real big source of confusion is the difference between Medicare and Medicaid when it comes to paying for your care. You may have heard of a situation, let's say, where someone had a stroke and they went to a hospital and then was sent to a nursing home or a rehabilitation. In that case, Medicare likely covered the rehab stay. But what happens after rehab? Long-term care is distinctly different. It really is referring to the care that someone needs on an ongoing basis because they can't manage daily tasks alone, such as bathing or dressing or eating or any other things that go along with independently living. This isn't short-term recovery from an illness or injury. It's care that's really permanent to some extent. Or if it's not permanent, it's at least for an extended period of time, unlike rehab. Medicare does not cover long-term care. This is where Medicaid comes in. But as you may or may not know, qualifying for Medicaid requires advanced planning. To the extent someone doesn't plan ahead, they may have to spend down nearly all or a large portion of their assets before they technically qualify. This is why we really recommend looking at long-term care planning strategies well before that care is needed and before the crisis occurs. Many families are shocked to learn that Medicaid, not Medicare, is the primary way people afford long-term care. Medicaid has very strict income and asset limits. And so without proper planning, families may be forced to spend down their savings in order to qualify for that Medicaid long-term care. An elder law attorney can really help protect those assets while still making sure you qualify for Medicaid benefits, which is, very, obviously very important for everybody. The key really is to plan before care is needed. And I know I keep saying that, and I really want to reiterate that, and I will continue to reiterate it. The time is now really to act. Waiting too long can really severely limit your options as you proceed through, or as you get older, or as crises occur. One of the most common concerns we hear is, will I lose everything if I need nursing home care? The answer is not necessarily. If, like we said before, if you plan ahead, then there are legal tools to your advantage, such as asset protection trusts, that can allow you to set aside certain assets while still keeping Medicaid eligibility later on down the road. But Medicaid has a 5-year look back rule, meaning that any transfers into say an asset protection trust, or in other jurisdictions, an irrevocable trust, meaning that if those transfers go into the trust, it must be made at least 5 years before applying for those Medicaid benefits. Hence why early planning is so important. Even if you or a loved one is already facing care cost or crisis planning, excuse me, I misspoke there. Even if you or a loved one is already facing care costs, crisis planning may still help protect some assets. So the sooner you explore that planning strategy, the more options you'll have. So I want to summarize what we just basically discussed, which is long-term care planning is about protecting both your health and your financial future. Medicaid can help cover long-term care, but qualifying requires planning. Legal tools like an asset protection trust here in North Carolina or an irrevocable trust in other jurisdictions, they can help you protect your savings and other assets. And the key here is the earlier you start planning, the more options you will have. So if you or a loved one, if you're thinking about your future care needs, or you're or are working with an elder care attorney, or you're not, you really should. They can help ensure that you have a strategy in place to protect both your health and your financial well-being, and again, your peace of mind, which is most important. What type of attorney are you looking for? We touched upon it earlier, but I'd like to go into a little more detail. There are differences, as I stated before, between someone who practices general law or general estate planning versus someone who is an elder law attorney. Think of an estate planner, if you will, as someone who kind of mainly helps decide what happens to your assets when you pass away. And in contrast, the elder law attorney really is someone that helps to plan for what happens while you're still living, especially if you face the challenges like needing long-term care, or you have a condition that affects communication, such as aphasia. So basically, if you or a loved one has aphasia, it's important that you work with someone who understands those challenges that can really help you make sure that your plan truly is protecting you. So now that you know precisely what to look for in an attorney, let's talk a little further about the attorney-client relationship, and more particularly how it works. I think one of the most important things to understand is who the client actually is. Many times we'll have a family member who will help set up like the appointments, but the attorney's duty, just so we're all clear, is always to the person who signs the documents. So let's kind of dig deep on that one piece if we can. One of the first things that attorneys will often explain to families is that the client is always the person who is doing the planning. Sometimes, attorneys will find that adult children or perhaps a caregiver, they can help schedule appointments, but the attorneys really, their duty is to the person signing the documents. They do this because it really ensures that the client's wishes are fully understood and that they're honored. In some cases, attorneys will even meet with the client alone, not because we don't trust the people that you have around you, your family or your caregivers, but it's simply to make sure that this is their own decision and that they're making that decision not only freely, but intelligently, and so that the plan will effectively do what it is that they're asking the attorneys to do. It's also important because it protects not only the client, but their family if ever there are some issues down the road. Another important legal factor in estate planning is capacity, meaning whether someone is legally able to understand the documents that they're about to sign. You'll find that this is especially important for individuals with progressive conditions such as aphasia. I'd like to kind of go over what capacity means, so I think I'm going to go in the next slide and we're going to talk a little more in depth about that and how attorneys will determine it and what steps can be taken if there are concerns. Legal capacity means that a person understands what they're signing and what it means for them. But did you know that legal documents like the power of attorney have different legal standards as it relates to capacity? So for an example, I referenced the power of attorney. The power of attorney, as a general rule, it requires a lower level of understanding than, let's say, an asset protection trust with complex trust provisions. We're obviously, or the attorneys would obviously want to make certain that with the complex trust, that the person signing it really truly understands what they're signing and what that document does. When an attorney meets with a client, one of the first things they typically assess is whether the client understands what they're doing. The attorneys will often do this by asking very simple, open-ended, basic questions, nothing that's going to be too difficult. If, for whatever reason, the attorney has concerns about capacity, they may recommend getting a letter from a client, from your doctor or their client's doctor. And this is done again to protect the client and their estate plan from future legal challenges. In making sure that a client has capacity, it isn't just a legal formality. It has to happen. We really need to make sure that that person has capacity. It's really what ensures that their documents will hold up in court, and that their wishes will actually be followed in the event that there is a challenge. If someone signs a document, but they don't have capacity, those documents have a strong likelihood of being challenged or even invalidated by a court. But we want to avoid that for obvious reasons. Um, this is particularly important when working with individuals who have aphasia, because aphasia affects communication, but not necessarily cognition or decision-making ability. So the attorneys, they have to be sure that they fully understand the client's wishes. If, for instance, aphasia were to make communication difficult, then the attorneys always kind of generally say, just be patient with us. They may need a little bit of extra time, tools, or resources to assess capacity accurately. So this is more for family members, but if you are a family member or a caregiver, it's advisable that you let the attorney that you're working with know about any communication methods that can help the attorney better understand how to effectively communicate with the client. Also, please don't get upset with the attorney if they ever recommend that you, as the client, get a doctor's assessment before signing any documents. It's not a reflection of the client's intelligence or decision making. It's really just a simple ask, and it's an added layer of protection to ensure that a client's wishes are really honored and that no one can challenge those documents later on down the road. If there are questions about capacity, there are a few steps that attorneys can take to ensure that the plan is strong. First, they may recommend getting a doctor's evaluation, which I just talked about, and that evaluation would confirm that the client does in fact have capacity. The attorney may also make sure to use clear, simple language when explaining the plan, and they document everything exceptionally carefully in their notes and in their file. And by taking these extra steps, it really can help prevent a lot of legal issues. And it really can ensure that the client's wishes are honored and that the documents will do exactly that which the clients have asked the attorneys to have them do. So now that we've talked about capacity, I want to focus in on another important issue, which is how to prevent legal challenges and claims of undue influence. Um, Even with a strong estate plan, I want to qualify that, because even if you have a strong estate plan, there's nothing to stop somebody from later on down the road from making the claim that the client was pressured. They didn't know what they were doing, and they were forced into a decision that wasn't their own. That obviously can lead to legal costly legal battles, and we want to prevent those. And so these next series of slides will kind of focus in on how we can prevent that from happening. So undue influence is when someone, not the client, is pressuring or manipulating or taking advantage of that client and really trying to influence their decision making. And those decisions may not truly reflect what the client's wishes were or are. This can happen sometimes in families, it can happen with caregivers, it can even happen with professionals. Uh, because these situations can lead to legal disputes, attorneys take extra precautions to really ensure that the client's choices are their own. And so I would like to go over a couple of those next slides to protect the client's estate from the undue influence claim. Attorneys generally have several ways to help prevent undue influence. First of which we typically always meet with clients privately. This is done so that there's a confirmation that the decisions are truly theirs and not someone else's. Attorneys will also ask those open-ended questions that we talked about earlier. This is done to make sure that they are thinking independently, that the client isn't just repeating perhaps what someone else told them to say, or kind of parroting a few statements from someone else, a third party. Finally, if there are concerns, the attorneys may recommend that, again, that doctor's letter to confirm capacity. And additionally, throughout the process, attorneys really carefully document everything in their file. And this is a way to ensure that there's a clear record of the client's wishes, so that if there is an undue influence claim, they can fall back on that and rely on that a little bit more as evidence that this was what the client wanted. There are some warning signs, a few in particular, that could make an estate plan more likely to be challenged. Um, if a client suddenly changes their entire estate plan to benefit one person over another, that's definitely going to raise some eyebrows. And for me, those are big. So the big eyebrows would be raised. It would raise red flags. If a family member is doing all of the talking while the client remains fairly silent, sitting kind of back into the corner while someone else takes charge, uh, the attorneys really want to make sure that the client is really truly making their own decision. And finally, if someone new, like a recent caregiver or a distant relative, suddenly becomes their best friend or their financial decision maker, that's another real big red flag for their attorneys. So the goal really is to make sure that the client's choices are not only well documented, but are really protected, because we don't want someone else driving the bus. The client really drives the bus. So the best way really to prevent legal challenges is to plan ahead and make sure everything is documented properly. So by starting early, before there are really any concerns about capacity, is crucial. It also helps really to communicate your wishes with trusted family members, so there are really no surprises like towards the end if say dementia or aphasia or any of these other things come into play. So well, I guess by working with an experienced elder law attorney, this can really ensure that everything is done correctly. And if needed, a medical evaluation really can provide that extra protection as well. Finally, keeping copies of all of the signed documents in a safe place really ensures that they're accessible when they're needed. And so, which is wildly important when you're talking about your originals. You don't want those destroyed or ruined in any ways, because they can affect the validity depending on the jurisdiction that you're in. Now that you have a plan in place, the next step is making sure that your loved one understands it, right? Talking about your estate planning and your long-term care can kind of be uncomfortable for certain folks. It can cause stress. It can cause a little bit, well, let me back up. It can be stressful to have the conversation, but the goal of the conversation really is to limit confusion and reduce stress. Um, it can even limit family disputes later on down the line when someone says, well, mom said this and dad said this. It can eliminate those disputes if you have those conversations. So I'd like to kind of go over how we can approach having those conversations. Many folks avoid talking about their estate plan because they don't want to upset their families or because they think it's private. But having these conversations now actually is a helpful preventative maintenance, if you will. It prevents that conflict that I was talking about a little bit earlier in the future when you do pass. It also ensures that your loved ones really and truly understand that what your wishes are, and they have time to prepare for any of the responsibilities that they may have been designated to, such as the attorney in fact, or if it was a trust, maybe a trustee. Whether you're naming a healthcare agent or a financial power of attorney, letting them know ahead of time really makes everything easier for them. It's really a gift for your loved one, so they can mentally prepare for any of the actions that they may have to take if or when you either become incapacitated or upon your death. Starting the conversation can feel a bit daunting from time to time. We've had experiences with clients who have mentioned that, but it really doesn't have to be. I think if you pick a time when everyone is calm and not distracted, you could even begin by sharing why estate planning is important to you. Maybe you've seen a situation where a lack of planning caused stress for a family or a family member or a friend. You can also use real life examples like, I want to make sure if something happens, you don't have to go to court just to help me out. And if you have a probate court experience, that would be a good time to insert that experience and how it impacted you. Most importantly, reassure your family that this is your plan, that this is your decision. You just want them to be informed. You don't have to share every single detail of your plan with everyone, but there are some people that you should talk to now once your estate plan is in place. To the extent that you've named someone to handle finances or medical decisions, they should understand their role because that is a critical role. Again, that document, like for healthcare, it's for something, a crisis incapacity. Close family members who may be affected by your plan should also be informed so there's no surprises later on down the road. Anyone who will need to take action when the time comes should have that general idea of what to expect. And it's also a good point to kind of reiterate your wishes so that they know when they're operating in that capacity that they're actually doing that what you wanted them to do. A common question the attorneys get is, how much should I share? And the answer really depends on your comfort level. Every family has a dynamic, and so you'll know better when it's your family versus someone else whose family dynamic may be different. You don't need to disclose all your financial details, and that's imperative, but your named agent should have enough information so that they can carry out their role. And when I think of that, I'm really thinking about, like, if you were doing online banking, for instance, they're going to need access to those online accounts or, your checkbook, things of that nature. For other family members, though, just a general basic overview should be sufficient and can prevent, at least at a minimum, misunderstandings as you get down the road effectively. So sometimes family members may not agree with your choice, especially if they expected something different. And that can be a little bit more of an uncomfortable conversation. If it does happen, one of the biggest recommendations, maybe it's the police officer in me, I don't know, stay calm, stay calm, stay calm. Remember that you are in control, that this is your plan, okay? It's based on what's best for you. And that's the most important key element. If you needed, you can involve a trusted advisor or an attorney, and they can help explain your decisions. But the key is to be clear, be confident, and that they know that these are your wishes. So that is the most important thing I want to drive home. That this is your estate plan. It's nobody else's. It's your decisions. And so if someone's not happy about that, that's on them. The key takeaways here is that talking about your estate plan now can prevent a lot of stress and confusion later. You don't have to share every detail, but again, key people should understand their roles. And if difficult conversations come up, stay calm and confident. Your decisions are what they are. They're important to you, so it's okay to communicate that to your loved ones. And again, if you need, feel free to bring in your attorney and another professional, and they can always help kind of guide that discussion, act as that neutral and detached third party to kind of make sure that no one gets heated or out of control. Okay, so we've covered a lot today, from estate planning basics to protecting your wishes and having important conversations with your family. Now I'd like to open this all up for some questions. If you're a resident of North Carolina, I just again want to reiterate that I am not licensed in North Carolina, but we do offer, or would love for you to reach out to our attorneys here at Carolina Family Estate Planning. Our office is amazing. We have a wonderful group of support staff. If you're in another state, we also share some resources on how to find a qualified elder attorney near you. So finding the right attorney is important, especially if a loved one has a condition like aphasia. Again, not all estate planning attorneys have the experience with elder law issues. So be sure to look for an elder law attorney, not just a general estate planner or not a general practitioner. You can get yourself into a little bit of a bind there if the documents aren't prepared accurately. When choosing an attorney, ask about their experience working with individuals who have communication challenges, or folks who have dementia or aphasia. It's also important to find someone familiar with Medicaid planning, long-term care as well, and also asset protection. Because again, like I highlighted earlier, those strategies can really affect your assets if you don't plan appropriately. You can typically start by looking at online reviews. I think a lot of people now, with the advancements of the internet, can quickly learn whether or not a firm is reputable or not. You can ask for recommendations. So if there's someone that you know that had a wonderful experience with an elder law attorney, it may be worth getting their business card, or just reaching out or checking out their website. And schedule a consultation to make sure that that attorney is a good fit for you. There's a cult of personalities in our world, and attorneys are humans too. Sometimes they may be the best attorney on the planet, but you just don't resonate with them, and that's okay too. As long as the attorney understands that your needs and how to communicate effectively with you and your loved ones, I would say then that would be the checkbox for whether or not they're a good fit for you. And I am done. I wanted to open it up to questions, and I wanted to also say thank you to Maura, as well as the National Aphasia Association. I can't thank you all enough for having me. And I'm going to stop my screen share.
I can help that with that.
If you want. Thank you. Perfect.
All right. Hey, everybody. First of all, Chris, oh my gosh, that was just wonderful. I really enjoyed not just hearing how you broke it down, but the key takeaways after each area to summarize is huge. I want to assure everybody that's out there listening to us today that we are sharing this recording on our YouTube channel, so you can go back and re-listen to it. The other thing that we do is we provide some resources. And as you were talking, Chris, I kept jotting down some other resources that I know of that
Fantastic.
will definitely be adding to the summary that goes both on the YouTube channel and on our newsletter. So please, make sure that you check both of those out after, because I'm going to be adding a bunch of resources. We got a lot of questions.
Okay.
I had a couple just quick comments before we start on that. One is that I wanted to thank you especially for your comments about ask an attorney that you're going to be working with, what are their experience working with aphasia. I think that everybody in this, a community needs to remember that they are the advocates for themselves, and that
100%.
starting out with, do you know what aphasia is? Here, let me take an opportunity to tell you what it is. And to also, if it's primary progressive aphasia, so it's part of frontotemporal dementia or another progressive disease, that is another thing that you really need to get the ideas of, has this person worked with anybody that is going to be getting worse instead of better, and how do I address that? So I really loved that. And I also wanted to add that in search of capacity, and also just in every conversation you have, to ensure that the client is the one whose wishes are being honored. I just love the focus you had on slow down, be patient with the attorney, but also engage any communication supports that might be necessary. We have resources for you that you can take to a lawyer when you're talking to them, just like we do for when you go to the doctor, where you spend some time before, you talk about what you're going to say, and then have those resources available, pictographs, or make sure you have a dry erase board or paper and pen. So it really,
I
really,
love that from my perspective, that feedback, and I can't thank you enough for that, because, I want to be able to, or our attorneys really want to be able to communicate. And I communicate differently than others, and I receive information differently than others. And so we want to be able
sure.
to provide that for our clients. And I'm quite certain that every attorney does. And I would tell you right now, if I was still in practice, that I would absolutely welcome any of those resources or materials. It would just help me to be a better advocate for our client, which is also important.
Wouldn't it be great if every agency, including police officers, and
Mhm.
had a packet of resources that were available there to help? That is our goal, and that's what we're doing here. And Kat was just asking, where can you find those resources? I can actually, I'm going to include them in the summary of this, but as we're working on our new website, they're actually going to be a whole page of those resources. So also just email me at answers at, absolutely. So I'm going to start with some of those questions. And one of them, and I'm kind of will work a little bit backwards, because you just finished talking about an elder care attorney. And
Mhm.
one of the questions is, what if your loved one is a young person, is somebody who has aphasia? We say two things. One is aphasia doesn't discriminate. Anyone
Right.
can have aphasia. There's unfortunately way too many young people having strokes and having aphasia, or being diagnosed with primary progressive aphasia young. Um, and second of all, if you've seen one person with aphasia, you've seen one person with aphasia. So
That's right.
everybody has different communication strengths and opportunities. So do you still recommend an elder care attorney if the person is a young person, or what to talk about all these same issues?
I would say yes, I would. And the reason being, as I pointed out in the slides, is there are certain trainings or certain experiences and certain things surrounding asset protection that are really imperative, particularly for young people. What I mean by that more specifically is, to the extent that the child or younger person may need government assistance through SSI or SSDI or any of the other acronyms that are out there, and please forgive me if I don't name them all, but there are certain types of trust that can be created to protect those government benefits, so it doesn't kick them off the aid to the extent money is given to them. And it's typically referred to as a supplemental needs trust. Sometimes they'll be called a special needs trust. But elder law attorneys, and even some general estate planning attorneys, will have a good concept or understanding of that. But it really, to be clear, without knowing specifically the issue surrounding that particular person, it really also boils down to comfort level. And I want to be clear
Yeah.
on that, because if you're comfortable and the attorney has a good grasp of the situation, comfort is paramount, I think, and that's wildly important. And
Yeah,
I
I
hope
really
that
like.
answered the question.
Yeah, I think that emphasizing that they have different trainings regarding asset protection is really huge. So I
Absolutely.
like that.
And other
If
things
some
too, like the power of attorney and the healthcare power of attorney. There are other things there to consider as well when we talk about that estate planning unit, and they can
It's
really
true.
kind of hone in on what really the child or the younger adult needs, because there are things to consider that someone who's more elderly may not have to consider, and off the top of my head, I think of reproductive rights. There are certain things that may need to be articulated in the power of attorney or in the healthcare power of attorney or the healthcare proxy, depending on where you're at.
Yeah, those were very important, those first ones that you talked about, because they get confused, I think. People think power of attorney and it encompasses everything, and it's certainly
I
doesn't.
agree. I don't love the nomenclature sometimes because you
Right.
think of a power of attorney and it's not really all encompassing. They're really individual documents. There's a financial power of attorney. It can be called a durable power of attorney, a general durable power of attorney. I mean, so the names go on and on, but basically think of that as financial. The healthcare power of attorney or a healthcare proxy or any of the other health directives really just direct what the wishes are of the patient. And it lets the doctors know what their wishes and wants are as well. And it allows an agent to advocate for them.
Love that. Okay, there's a couple more questions, so I really want
Please.
to try to get to. So one of them was talking about somebody who has a severe, and of course, Chris isn't going to know about all the types of aphasia, but a severe global aphasia. So they have good so they have comprehension and some gestures, but basically comprehension and expression are both impaired. And they were asking about consent and getting uh, competency and capacity assessment. And if they're going to be making important decisions, can you have other people involved? So I think that one of the questions is, is an attorney with a doctor's note enough, or sometimes can a speech pathologist help out and share? I know I've been called in on cases before where they needed somebody to share the communication support. So people with more severe, can they be considered able to consent in important decisions?
I'm going to give you the quintessential attorney answer, which is
Okay.
it depends.
It depends.
It
Yeah.
really depends on the person. It also depends on a number of other factors, many of which we did cover in the presentation. However, some jurisdictions may require, and it's also going to depend a lot on the comfort of the medical professionals
Yeah.
as well as the attorney. And if they can collaborate and work together as a team, great. That may not suffice though. It may not be enough. And so oftentimes you'll see the medical professional does not want to sign off on that. And so they may kind of punt to the court to make a determination. And so you may be limited again if that particular individual is at a point where it can't really be determined that there's capacity. They
Yeah.
may need a court determination. And what that is typically done is through guardianship or conservatorship, depending on where you're at. Then a judge would appoint someone to effectively make decisions on their behalf. So it
Yeah.
really
It
depends because
actually,
it's such a wide range, on where you are and how each case is literally taken on a case by case basis. So I apologize for being intentionally vague, but there's a wide swath there.
no, I think that's really fair. And one of the other things I would add as a speech pathologist for 38 years is to make sure that you ask your speech pathologist to write a letter, to give information on how
Absolutely.
they can assure, because they're the ones doing the testing. So a doctor is evaluating other things, but remember the value of the speech pathologist that's working one-on-one with a person with aphasia.
And to your point, that's a great point that I want to highlight too. When I said collaboration, it really is a team. That's the part of
Yeah.
estate planning that I think a lot of us really enjoy. We work across the aisle with a lot of different folks, whether it be medical professionals, speech pathologists. It doesn't really matter because the goal really is to make sure that the client is cared for.
Love it. Thank you. And one of the first questions came on, if you have, so this, and again, I know you might not be able to answer for this individual person, but it says, I have documents that state my husband is my advocate. However, he has a known TBI, traumatic brain injury, with aphasia. So wondering if I should put my daughter as contact. Can they share this role if his decision-making is impaired? How does that work when you have other family members and kind of choosing who can speak for you and help you out if one person does? It's the other part, not that the person with aphasia needs the voice, but the other person needs a voice.
So we define that as, I'm understanding that to mean the principal, the person who is going to have agents work for them. And then the agent, her agent perhaps could be her husband who has suffered the TBI. In that particular circumstance, it depends really largely on that wide swath of her husband's, the spectrum of which he's on that TBI. If he's able to effectively
Right.
communicate and advocate and do all of the things that, you would expect your agent to be able to do for you in that position, then certainly he can serve in that capacity, provided that he has capacity. Um, if he's not able to effectively communicate on behalf of the principal, my biggest concern always becomes if there's a delay in that process. And I always, because I was a first responder, I always think of the car wrecks or something really catastrophic happening.
Right.
That delay in getting the next person in line to go and act as the agent could literally mean life or death in some circumstances. Certainly not all, but there are circumstances where it might be an emergency. And so, and it also would depend if I could back up a little bit on largely on how the document is effectively created, meaning are they acting together and making a decision, the agents? Are they working individually? And if one can act individually, failing which the second can act, then you can see where that might be a dynamic. But if they act together, it might not be as big of a problem. So it largely depends on the type of document that is created and the jurisdiction that you're in. It also largely depends, I think, on the event itself too. So
I think it emphasizes your point throughout, which was communicate early, have
yeah.
a conversation. Don't wait till something happens. Sit and have that conversation with your whole family so that there's less stress when something does need to happen.
And I
And I'm
wanted
just
to
gonna,
highlight that one piece because
yeah,
ultimately, again, that situation where there's a car wreck or something like that, everyone should really know their role so that they can
yes.
advocate for you as soon as practicable after any incident that occurs, whether that be heart attack, stroke, any other crises that can occur. So
Yeah, and I will say after, we have employed these services myself in my own family when my mom had her stroke, but also for our own personal family. And that conversation of having with our sons and saying, this is where the information is, these are the binders, and have those conversations. Boy, it's much easier to do it before there's all that stress. I'm
couldn't
going to
agree,
finish up
couldn't
with
agree
one
more.
question only because I don't want it to go un unanswered to a general stand. I know you can't
Please.
make everything, but people are, how much does this type of thing cost for a family? And can any, does everyone qualify for any kind of, is there assistance? And I know there's a lot of Medicare, Medicaid questions, and we will be able to add you some resources to that. So I guess
Mhm.
I'll focus on the question of, yes, this is an investment, right? This is costly at some time for people in general.
Yes. It is an investment. It's generally costly. But asking specifically how much it costs is like asking what does a red car cost,
Right.
in my
Right.
humble opinion.
Yeah.
It really does depend, because I want to be clear too, estate planning isn't just it's a strategy. And so there is a strategy behind it, and that's unique to every individual. What works for you, Maura, may not work for me and my family. And what works for someone with aphasia may not work for somebody who has a TBI. It's gonna be tailored to you specifically. And so it just depends. There are many different ways that a prospective client could be charged. In estate planning, typically you do see flat fee services, but there are times where it may be so complex that it's billed on an hourly rate. And it really just largely depends on the client. It largely depends on the situation, the complexity of the estate plan. To your point earlier, the earlier you can get ahead of that, it may defer some of the cost, because the more
That's right.
complex, the more expensive it will get. But it's really, it's a really sliding scale. It's really hard to nail down an exact number. So I apologize for the vagueness on that, but
No, I just think
again,
it's
it's also going to depend largely on where you live. So what we may charge here in North Carolina certainly wouldn't be, say, what they charge in Maryland or Massachusetts or Pennsylvania or New York or New
sure.
Jersey. They may see it's more expensive. I have heard in the past, and I won't say this with certainty, but that uh, an elder law attorney may charge the equivalent of 1 month stay in a long-term care facility, but that's not the standard. That's not the norm. It's just I've heard that in the estate planning world.
Well, I wish we could get to all the questions, but again, please, I know that I will follow up with all the questions. I do get a list from Zoom of the questions, and also feel free to reach out to answers@aphasia.org. Chris, I cannot thank you enough. It was just fantastic. And I know this is one that people will keep going back to over and over. And really, you guys are welcome anytime. I know there's some great resources that we can pull together. So
I
thank you.
can't thank you all enough for having me. I really appreciate the opportunity to talk to you all. And if you guys need anything, please use us as a resource.
Thank you. Thank you so much, Chris. And I'd like to also thank Elsie for helping me behind the scenes, sending the information. I don't know why my screen.
It's me again.
It is. Just want to remind everybody in closing that we are actually working on our website. You will see big changes coming very soon, but there is this little section that says find support. And when you go there, you will find our calendar. The calendar will have all of the groups that we have going on, and just click on that to get to your link. Finally, if you need anything, please reach out. This is what we're here for. We're working really hard to make a difference in the lives of people with aphasia and their families. So please reach out to answers@aphasia.org. And note that Elsie is going to drop, by the way, in the chat, the link for the PDH. If you are a professional who watched this live, you can access that. And then after the Ask the Expert, there'll be a little bit of a survey. It'd be real helpful for you to give us some information, and also keep us in mind for what types of programming that you would like in the future. We want to provide these Ask the Experts for things that will help you and your family. So thank you so much, Chris. Thank you, Elsie, and we'll talk to you all soon.
Thank you, everybody.
Bye. Have a good evening.
You as well.